Welcome to Litigation and Capital.
Hey everyone, welcome back to an all-new episode of Litigation and Capital with Stephen Mirsky. I am your host, Mike Leon. Stephen here is the founder of Mirsky Corporate Advisors, and in each episode, we've been breaking down high-stakes legal issues affecting companies like yours, those earning 10 to 100 million a year, so that way you can turn that complexity into leverage and protect what you've worked hard to build. Today's episode, we're going to be talking about the kind of contract terms that create an immediate built-in default long before there's any dispute that ever reaches a courtroom. Stephen, it's good to see you as always, my friend. What does, because this episode is about engineering default or engineered defaults. What does engineered default mean? What the heck does that mean in the context of high-risk financing and these MCAs that we were talking about in previous episodes?
An engineered default is where, what I like to say, you as a borrower have defaulted upon signing the deal. So how did that happen? Why would I ever do that? Well, you as the borrower or the business owner doesn't typically realize that that's what they're doing. So let's talk about real quick, how do people typically get in these MCAs and look at the concept there? Well, typically there's a broker involved and the broker says, hey, look, I can get you some financing. But I can't get you all from one place. So I'm going to get you from party A and party B. Okay? So party A and party B both have similar deals. I need the money today. I don't really care. I'm going to sign it. I don't have a chance to negotiate it. So I signed both deals. And then typically there's going to be a call. And the call is what I like to say, it's a tool that they can use to get you in bankruptcy court to show fraud. And in this call, there's some verbal representations that are made about your creditworthiness, but you're being coached by the broker. And the broker's often saying, hey, don't tell them about the other deal. Hey, it's totally fine. Don't worry about it, right? This is just a formality. So the borrower does what they're told and they move on down the road. Well, where's the default? Well, there's a provision common in all of these agreements that's called no stacking. Well, what's stacking? Stacking means that I have basically a junior creditor, right? So if I'm a normal business owner in an MCA agreement, I've got the SBA loan, and now I've got a merchant cash lender in the second position, and then let's say in this example, I'm bringing on another one. There's one in the third position.
Right.
So it says I can't have any junior lenders, but if you're bringing on two guys at the same time, one of them is going to be junior to the other. So now I've violated to either of them. I violated a stacking clause. Stacking also comes in the fact of like, oh crap, my cash flow is getting tight. These guys are taking way more money than I need. I need to make payroll. Like, what's going on? Like, I got to pay these guys off. So I'm going to take it on another MCA deal because now that I have an MCA, the institutional lenders won't touch me. SBA won't finance these things. So now I need to bring on a third guy just so I can make payroll next week. So now I've done that. Well, now I've defaulted the stacking clause, or I've breached the stacking clause again. And so that is how these things typically come into place. There's other ways that it could do it. I've got another example that we talked about on a prior episode where there's 50% of the specified percentage, meaning how much the lender has the right to withdraw, was 50%. But the dollar amount, the cash, didn't equal 50%, right? So like, let's say that they had a right to specify a percentage of 50%, but the cash that pulled out was maybe like 2%, right? So if I wanted to reconcile this, I can't use it because they've never pulled the 50%, and because I've breached the stacking clause, they're going to say, well, I don't need to do this because you've already breached. So this is a common scenario that happens with these receivable purchase agreements that create an engineered default.
How have you seen the courts kind of evaluate clauses that trigger the defaults automatically, but it's based on like factors the business can't realistically control? Like, how have you seen the court evaluate those type of cases?
It's going to go down to the facts. What were the behaviors of the party going into it and after the event? And then, as we talked about in a prior episode about the characterization of a loan or true sale, it kind of gets baked into all of that. Mm-hmm. But there's a general sense, at least in my end in California, that there's something not quite equitable in these agreements. And so there's a little bit of skepticism as to uh, the reactions to a default that may occur under these agreements.
Stephen, let's go back to what you're talking about with stacking, because I know a lot of contracts, and you can correct me if I'm wrong, they prohibit stacking, right? Or taking additional financing from all these other sources, like you mentioned. How do judges, though, assess whether the provisions function as like legitimate mechanisms that are designed to ensure the default?
I would say, from the MCA's perspective, it's there to protect their security interest. And from the judge's perspective, I think it goes back to, what's the impact of this default? What's the actual damage caused? And there's all sort. I kind of have to meander in this question, but there's all sorts of things that can happen with these default clauses. So, like for instance, some of these agreements say, "Hey, well, here's a default fee. The default fee is $5,000, right? So if you violate the no stacking clause, it's a $5,000 surcharge." Well, if you're saying it's a $5,000 surcharge, why are you going to freeze the debtor's assets to collect all of their money, right? There seems to be some sort of inequitable approach here. And so I think that's where the court focuses on, is the heavy-handedness of the responses in relation to the technicality of the default. Yeah. And then from another, and I haven't seen courts weigh in on this too much, but there's a logical issue too. The logical issue is if you've only bought, let's say, I don't know, X percent of the receivables. So let's say the client let's say that their average monthly gross revenue is $2 million. And let's say the contract's $500,000, right? You only have rights to 25% of those receivables. So that would mean that conceptually that the debtor has rights to 75%. It can do whatever it wants with that 75%. So there's this tension between the stacking provisions and ownership rights between the debtor. And I don't think that issue has been fully fleshed out in the courts yet.
Let's talk a little bit about some of the cases you've handled. With respect to those, what have you found from the funder's own comms or their internal records? What does it reveal to you about their expectations, regarding the default and collection?
I have to speculate a little bit, but my hunch is that these agreements are means to an end. The way I look at that is that these deals are intentionally designed to be fixed payment or as close to fixed payment as they can be. Even if there's a reconciliation, I've seen these guys say, "Oh, I can only adjust it down 10, 15%. Well, that's not based on your actual revenue. That's just adjusting it 10, 15%. Why? My thought is that these guys create funds and they've got borrowers and or debt obligations connected to those funds, and they're using the proceeds of these funds to get small business, mid-sized business clients. And so because they've got their own debt obligations, they need you to pay on time. And that's where I think the other tension lies in this ecosystem.
So then how do the courts, or how have you seen the courts look at situations? Let me give a scenario here. The funder's claiming to have purchased receivables, but they're still enforcing repayment schedules, kind of as if the business owns a fixed loan balance. How have you seen the court handle situations like that?
I mean, it's sort of it's the issue of the dispute, right? Is they're saying, "Hey, I'm not going to adjust your payments. You need to pay me back. I've got your business by the balls." And now the debtor is going to try to sue, or they're going to sue the debtor. That's how these cases come up. And so how is the court looking at it? The court's going to look at, is it a loan or not? Is it, what's enforceable? What are the facts surrounding the dispute? And then the court's going to make a decision. But, like I said, most of the time these things settle out.
Yeah. I had by the balls written here for you, Stephen. I was going to ask that next. You jumped the gun there now. So let me ask you one more thing, though. How, as well, have you seen the courts examine, or what do the courts examine, I should say, to determine whether like a default trigger was included primarily to accelerate the remedies, or even maybe create that immediate leverage that we've been talking about?
Generally speaking, the court's not going to spend a whole lot of time analyzing that factor in and of itself, right? It falls within a subset of another analysis, right? And that analysis is whether or not the transaction is a loan. And so it goes back to allocation of risk, right? If the debtor is likely to trigger 1, 2, 3, 4, 5 different representations, whatever, on an agreement just by signing, well, then there's really no true allocation of risk to the buyer. And so that's how it comes up as relevant within the analysis of the court. I think the other issues, let's say we're seeking a temporary restraining order or an injunction, I think the manner, the quality, the method of communication between the MCA lender and the debtor, I think that has a material impact on a court's analysis.
Stephen, as we wrap here, for the folks that are listening to this and they're reviewing these agreements, what are some specific clauses they should start looking at? Because the courts are going to routinely scrutinize them as maybe potential early default traps. What are some of those?
I would say that this entire agreement is designed for you to default. Whether or not there is a specific clause in there, you're going to default on the cash. They're designed so that you fail, right? More often than not, you won't be able to have the cash flow to make the payments. What do I mean by that? Well, let's say your revenues are $200,000 a month. The MCAs are going to say, well, we're going to take X percent of that every day, whatever it is. Well, your cash flow isn't, just because you get 200 grand in a month doesn't mean your cash flow is consistent every day, right? You have payments come in lumpy. You have payroll that goes out. And so you're going to reach a trigger where the actual cash on hand is going to be less than the amount you owe, and they're going to pull it, and now you can't pay your employees, and now you're hooked. Mm-hmm. That is where this comes through. And why does it happen this way? Because the business owner is looking at it from I make X amount a month, I'll be fine, without realizing all the other expenses and the timing that comes through. And so if your revenue is pretty consistent, but the timing of the cash is inconsistent, that's where you're going to breach these things. And that's where you're going to have a lot of headache. And so, and the last point here is these contracts aren't really negotiable. This is their form, take it or leave it type of a thing. So from the business owner's perspective, they are what they are. What you can control is your openness to risk. And for that, you need to do a good cash flow analysis and determine whether or not you can actually survive this agreement. Otherwise you're going down. Right. Bottom line. I mean, I've had cases where people were making over $50 million a year with 30% margins. They go out of business in 6 months because they signed one of these deals, right? It's just, It's a very dangerous ecosystem, and it's a very dangerous financing tool.
That's why they need somebody like you to help them along the way. Stephen, thank you again for the time, the insights. Appreciate it as always, my friend.
Thank you.
That's it for today's episode of Litigation and Capital with Stephen Mirsky. If you want to learn more, you want Stephen and the folks over at Mirsky Corporate Advisors to help you guys out, visit MirskyCorporateAdvisors.com right now to connect with Stephen and the team. And one more favor, as always, hit like, hit subscribe, leave a review, comment, share it with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.